Thank you so much for joining us this evening. We are happy to present tonight's webinar, The Keys to Locking Out Lawsuits for Healthcare Professionals, presented by Stephen Culmer from Legally Mine, LLC. Make sure to join us next month where we will have Dr. Richard Seymour discussing how to stop false healthcare for women. That's going to be Wednesday, May 12th at the same time, 7 p.m. Central. Let me go ahead and introduce Stephen for you. Stephen Culmer is a seasoned entrepreneur with over 30 years of experience in the business, startup, and investment education, business ownership, and growth in the public and private sectors, as well as domestic and international business consulting. He has a wealth of expertise in areas such as early stage and startup entities, professional instruction within seminars and workshop related to investment and business structure, and most importantly, asset protection and tax structure. We appreciate him being here, giving this presentation. I'm going to go ahead and stop sharing my screen, and Steve, it is all yours.
All right, thank you very much. I'm actually going to share my screen. It's my pleasure to be here this evening. Again, my name is Steve Culmer, and on behalf of Legally Mine, we're excited to always sponsor these types of events and help facilitate the CME and the CE credits that we facilitate, which we'll be doing here tonight as well. Very quickly, just a couple of things about me. I always said I should change that bio. There's just a couple of really quick points. One is I actually got started in the asset protection side of things back in 1985. So it's been a long time ago. I got involved with a gentleman by the name of Jay Minton, an attorney who later became known as the father of asset protection because of several of the strategies and more that we're going to be sharing tonight that you're going to learn about. In fact, typically we'll say you'll typically come out of a presentation like this knowing more than about 95% of the attorneys out there about how to protect your assets. So exciting topic. We're going to be covering these points as you see here on your screen. And just to remind you again, if you have questions, which I'm sure at some point in time, you may have some questions about some of the things we're talking about, just make sure and jot those down so that we can, in the interest of time, we can get things done as needed and as quickly as would be normal. We won't get off on a tangent or anything like that. So just make sure you write down those questions. Usually I find that within 5 or 10 minutes of you thinking of the question, you actually have it answered for you during the context of the presentation. So, but make sure and write those down. We want to have those answered at the end as well. The other thing I'll mention to you, this is CE credit, and you'll be getting an hour of CE credit with this. What I'm going to do is this. I'm going to be instructing you about all of these things. And then as we're done with that education and that session, I'm going to go ahead and I'll let you know when we finish the CE portion. And then I'll let you know after that, I'll go through what Legally Mine can do for you if you're so inclined to make sure that you get yourself taken care of properly with regard to your assets and the protection of your estate. So I'll just do that and make it real clear at the end so that we know that's where that break off is. Excited to be here and would really like to just let you know that these are important things. You all know that. You've been thinking about it throughout your careers, I'm sure, both you and if you're married with your spouse as well. I'm sure you've seen other people in your area of expertise that have been sued or threatened to be sued and whatnot. And how would that feel to be served a, $1, $2, $3, $5 million, $10 million lawsuit and know that you're a party on that? That wouldn't feel very good. We're going to talk about how to eliminate that tonight and how to eliminate the threat. And also as a byproduct, I always teach as a byproduct of getting your assets protected in the structure we're talking about here. A beautiful byproduct of that is it's going to open up a world of new tax savings that you otherwise would not have had access to. Okay. Now I've spoken on this for many, many years and taught all over the world, actually, not only here across the US, but Australia, New Zealand, Singapore, Hong Kong, the UK, Canada, because people in those countries are wanting to invest and wanting to have businesses here. And I taught them just like I'm going to be teaching you here tonight. But let's put it in perspective here. Let's jump right in. We'll get it into some perspective. But the first thing I just want you to, we all know this. We all know that we have become an incredibly litigious country. From that very first case of the McDonald's hot coffee cup spilling in the drive-up window lap there of the person at the drive-up window, now it's just gone crazy. And we all know it. We're very litigious. In fact, to give you an idea, 5% of the world's population lives here in the US, but over 90% of the world's lawsuits are filed right here in the US. All right. Now, I forgot to mention this, but as a part of the CE credit, what we're going to do is we're going to have you, I'm going to give you a link when we get to the end of the CE session so that you can write that link down and you'll have just 4 or 5 questions that you'll need to answer as a part of, completing that, a little quiz. And so every time you see, as you do on this screen, some wording and answer, what have you, with asterisks on both sides of it, that just means make a note of that, because that's going to be a part of your little quiz as you get your credits. Okay. So 90% of the world's population, or the world's lawsuits, are filed right here. Last year, believe it or not, there were over 100 million lawsuits filed. It's just getting insanely crazy. It's a huge number. People ask me this: why are there so many lawsuits? I tell them it's because of the entitlement mentality that has grown and grown in our country. People think that what's yours is mine, as well as what's mine is mine. USA Today, in fact, did a poll a number of years ago asking that question. They did a little poll survey. The survey question was, what's the best way to get rich in America today? And then they listed the numbers. And the top answer was that the best way to get rich in America today is to sue somebody. Can you believe that? It's just incredible. Another example, a friend of mine, her and her husband sold their home to some quote unquote family friends at the time. 10 days after the closing, the family friends sued my friend and her husband on the basis of 7 different items that they said were wrong with the transaction, all 7 of which completely false. They wanted 35 grand. That's what they were suing him for. My friend and her husband went to their attorney and said, what should we do? He says, I think I can get him to settle for about $18,000. Now think about that. We all know that's not good, not right, but it is what it is. She said, we're going to fight it. They took it all the way to the end. And at one point in time toward the end, they were all in a conference room together, the plaintiffs and my friend and the attorneys of both parties. She got so frustrated with everything. She stood up and slammed her fist down on the desk and said, why are you doing this? And his answer, I'm going to quote right here on the screen, because it's so telling about that mentality. He said, because you have more than I do, and I need it more than you do. Now, can you believe that? That's just insane. I'm just telling you, things have gotten crazy. You know it. I know it. Big reason for that, number one, is because our nation is run by attorneys. You think about it, there are over 85% of the sitting congressmen and women and the senators up there all are attorneys. So that's a huge percentage. The other thing, well, first off, in whose best interest are they going to write the laws then? Of course, they're going to write the laws in the best interest of the attorneys, right? And the second thing is this, that there's no real consequences. There are no negative consequences in the US for suing someone frivolously and losing that lawsuit. Every other country in the world has some consequence. Guess what? Here in the US, of course, we don't have that. It would make sense, but we don't have that. And so people can sue and sue and sue, and they can lose and lose and lose. And then all of a sudden they hit one that's the jackpot and they got their lottery ticket. So that's another big problem. It's not going to go away anytime soon. There are more and more lawsuits filed every single year, which increases our odds of losing. In fact, interestingly enough, 7 out of 10 lawsuits end up in a settlement of between $3,000 and $75,000. That means you lost. If you're named in a lawsuit and you have to pay to settle, in my opinion, settling is losing. Think about it. 100 million lawsuits last year filed, 70 million lawsuits ended up in a settlement. That's a multi-billion-dollar industry, isn't it? And you can see why those trial attorneys want to hang on to that with all they can. And of course, the other thing to remember is this, that you as medical professionals have a 50% chance of being sued at least once during your career. So we need to put a stop to all of that. Okay. Now, a lot of times people ask, why are we settling? Why are there so many settlements? Here's why. These are the 3 big reasons. Everybody knows if they get sued and they've got to get into it, they're going to go follow it through. They've got to waste a lot of time. They're going to be wasting a ton of money, because you're going to, right out of the gate, you're going to have a $5,000 to $10,000 retainer with any decent defense lawyer. And then of course the emotional strain. You don't know where it's going to end. You may be paying out all this money for that attorney. What if you lose anyway? You never know which way it's going to go. So that's what causes all that emotional strain. It's awful. And because of these things, people want to stay away from it. Now, I'm just going to ask you to do one thing for me tonight. While I go through this, I would encourage each of you, because this is so important, think about this in terms of your life, your financial future, etc. Think about these things, whether you're close to retirement or retired, because you can get sued after retirement. They can go back years and you can get brought into it. Or if you're building a practice where you don't feel like you have enough assets, listen, no matter what assets you have, those are your assets. And I can promise you this, if you're in court and you lose and someone takes those assets, that hurts. So you might as well protect it and then continue on. In fact, what I want you to do first and foremost to personalize this, I want you to think about what your number is. And when I ask the question, what is your number? I just mean this. What is the number that if someone sued you for that much or more, it would cause you to fight versus settle? Where is your threshold, let's say, for settling? It might be $10,000. And if it's more than that, I'm fighting. It might be $50,000. And if it's below that, I'm settling. Above that, I'm fighting. I just want you to think about what your number is. If you got sued tomorrow, what would your number be? All right. Now, I have actually experienced this in my own life, in that I've been a serial entrepreneur my entire career. I've been an international business consultant for many, many years. But prior to that, I had a couple of internet companies that I started during the first .com craze, that first one. One of them we sold off to TD Ameritrade in a nice little acquisition. The other one we took public, and that went well. In one of those companies, I had one of my management team members very upset one night, came into me. I don't know why. It was out of the blue. And he says, I'm quitting. He claimed to be upset with one of our other management team members, and he left. The next morning, first thing in the morning, he comes in my office with a 12-page single-spaced demand letter for me, demanding millions of dollars in unwarranted cash, millions of shares in unwarranted stock. And he even put my wife's name and the wives of several other of the management team members. So basically throwing the kitchen sink at us. So the short story is, I said, we're fighting this thing, and we fought it through. 3 years later, and $350,000 later of cash I had laid out, we won. Now, the question is, did we really win, right? I mean, we wasted all that time, energy, emotion, money, all of that. Bottom line is, I wanted to make sure that would never happen to me again. And I went out and started searching for a way to do that. I started pulling attorneys together. I spent over $25,000 of my cash to try to make sure it never happened again. And I still felt like there was a hole there, but it's very frustrating and expensive to do that. And so I decided that I would go a different direction, and I'll tell you about that later. But right now, I want to talk to you about the strategies that will help you beat the odds. You can win this. You can beat the odds. This involves uniquely structured entities, which we're going to talk about here tonight. Supreme Court backed. Everything you're seeing is Supreme Court backed. There are massive tax advantages, like I mentioned to you before. 10,000 plus annually is kind of just a generalized figure. It can be much more than that, depending on your situation, your structure. So we'll take a look at that and see how to implement that a little bit later. But let's take a look at why this works and how it works. First off, a lawsuit happens because there's always a cause and then a motivation for the lawsuit. The cause for the lawsuit, we can't always help, right? I mean, you have someone at your house, they trip and fall down your front stairs, they break their arm or their leg. Couldn't help that. That's the cause. But what we need to control is the motivation for the lawsuit. The cause is not going to go anywhere without the motivation. The motivation in these types of lawsuits, the motivation in any lawsuit that someone comes calling with, the motivation is one thing and one thing only, and that is money. If they can see, if that attorney can see, and they're very good at this, if they can see that you have assets and cash and et cetera, all your assets are exposed, guess what? They're coming full throttle. So you've got to understand that it's not about right or wrong. It's about money. And if we can take that motivation off the table, you're totally fine, and they're not going to come. All right. So let's take a look and see how to do that. The first thing you need to understand is what motivation you have. And typically what we'll do is you want to divide that motivation into two separate types of assets. You have safe assets, and then you have high risk assets. Safe assets by themselves cannot cause a lawsuit, will not cause a lawsuit. High risk assets, on the other hand, are assets that will and can cause a lawsuit all by themselves. Think about it. Your car is a rolling lawsuit just waiting to happen, right? So we want to make sure that we're protecting each one of these, because your safe assets are protected in a different way than your high risk assets. All right. So let's take a look at how we protect our safe assets first. And I want you to think again, which of these assets do I have? Which of these assets am I growing? Safe assets are assets that won't cause the lawsuit. Think about it. You may have, well, obviously you've got bank accounts, you've got investment accounts, retirement accounts. You know, some people say, well, gosh, retirement accounts, they can't come after that because those are protected by the state or the Fed. Well, the fact of the matter is they have been allowed to go into those because there's so much worth to them. There's so many assets in there. And so we do need to just protect it like we do all the other safe items you see here. You can tell none of these on their own sitting there will cause a lawsuit. Okay. Well, how do we protect them? Well, what if I told you that we could put 98% of your safe assets into a lawsuit-proof vault, and that vault had one key and you were the only one that had it and could open it legally. How would that feel? That'd feel pretty good, I'll bet, wouldn't it? Yeah, absolutely. And we can do that with puzzle piece number one, strategy number one, the family limited partnership. Now, as I mentioned this first puzzle piece, you noted that a couple of slides ago, I had 4 puzzle pieces on there, all locked together. That's how I see the strategy and the structure that we're putting in place. It's like 4 puzzle pieces that need to be interlocked to have that strength. And so this is first puzzle piece, the FLP, or Family Limited Partnership. Now, it's been around since the early 1900s and has proven very effective at protecting safe assets from the threat of lawsuit, as long as it's written and structured the right way. Now, the way that Family Limited Partnership is put together is you have a general partner and then you have limited partners. The general partner has 100% control, makes all the decisions for the Family Limited Partnership. The limited partners make no decisions and have no control. So here's the thing, because the general partner has 100% control and makes all the decisions, the general partner also has 100% of the liability in the event of a lawsuit. The general partner can be sued. And by the way, you can name yourself your general partner, a trusted friend or family member. You can name anybody out there, but the general partner has all the liability. Because the general partner has all the liability, you don't want to give much ownership to the general partner in your family limited partnership that has all your safe assets in it. Okay. So the lowest amount you can provide in ownership for the general partner is 2%. So let's say we give that general partner 2%. Okay. Well, now let's look at what happens. That still means that you or one of your family members, whoever you've named as general partner, is exposed to that lawsuit, even though they only own 2%. So what do? We set up a management company. Okay. You own the management company, but the management company is the general partner and owns the 2%. Now, there are 2 reasons why you would want to do this. One is you want to move yourself one step further away from any personal litigation or liability, which is what you're doing here. You're now no longer the general partner. Your entity is the general partner. But the bigger thing this does is this, now that you're not personally the general partner, you can now become, with you and your spouse, if you're married, you can become the limited partners in the family limited partnership. Now, notice these asterisks right here, make a note of that, but limited partners have no liability and cannot be sued in the event of a lawsuit. So because of that, because they can't be sued, the other 98% ownership would go to you as the limited partners. But if a trial attorney came and looked at this structure and was going to sue you and was looking into that possibility, and they saw this structure, think about this. How much is the most that general partner could ever hope to get if he or she did win the lawsuit? The most they could get is 2%, because that's the only person that can be sued. And I promise you that 2% of your safe assets alone is not going to be enough motivation for that trial attorney to pursue it, and they're going to drop it right there. It's going to stop it. And again, no liability. Make a note of that. All right. Okay. So now we've got the safe assets locked up. Now let's go and see what we need to do with our high risk assets. The high risk assets are assets that will cause a lawsuit or can cause a lawsuit by themselves. Your home, cars, motorcycles, vacation home, boat, and it can happen anywhere. Your office building, anything. So what do? We move to strategy number 2, puzzle piece number 2, which is creating individual entities, individual LLCs for each of your high risk assets. And you put just that asset in each one. Why do we do this? Well, let me share with you a little example real quick. Let's say that you thought you have 3 rental properties. You decided that you were going to protect those properties. So in order to protect them, you put them in an LLC. Well, that's great. But what happens if first off, let me just ask you this question. How many of you understand about LLCs? I just want you to think about this. The definition of an LLC and what it does. An LLC protects whatever's inside the LLC from an outside originating lawsuit. Whatever's inside is protected from an outside caused lawsuit. Okay. Well, in this case, let's say there's a fire inside the LLC. In other words, inside that structure. Could there be a lawsuit? Yeah, there probably will be. Okay. Somebody got hurt in there. So there's going to be a lawsuit, right? Okay. Now, where did that lawsuit originate? Inside the LLC or outside the LLC? That lawsuit originated inside the LLC, the asset that caused the problem inside the LLC. Well, since it's an inside lawsuit to the LLC, these other 2, not only can this property be taken, but these other 2 properties can be taken as well. There's no protection for them. And basically might as well have not had any protection in place. The way we want to do it is we want to do this. Take those 3 properties, separate them into their own separate LLCs. Now, if there's a fire in the one and somebody gets hurt, is there a lawsuit? Maybe. But the fact of the matter is, can they reach into LLC number 1 and take that asset, or reach into LLC number 3 and take that asset? Of course, they cannot, because this lawsuit is a lawsuit that is an outside lawsuit to LLC number 1 and LLC number 3, which means they're fully protected and they maintain their protection. And then they come back to the attorney says, well, it's not worth it. Why would we do it just for that? Right? Now, great way to protect us. So what we got to do is we've got to set up separate LLCs for each one of your own. They have to be written the right way. And this is the structure you want them in place. So they're all those high risk assets are separated out. Okay. Now, this is a phenomenal strategy. And in fact, I get the question all the time, who uses this strategy? Give me some examples. I'll give you 2 quick examples. One is Disney. Now think about it. What's the only thing you have to do when you go to Disney to get in and ride those rides? The only thing you've got to do is pay for a ticket, right? And you're in. Well, so Disney, let's just say that there's a 95-year-old grandma. She decides she's going to go make one last run at the roller coasters at Disney. So she pays for a ticket, goes on in. That's all she had to do. She goes in and gets on Thunder Mountain Railroad. Okay. She rides that coaster around and around and around. Sure enough, she gets hurt. So she decides she's going to sue Disney. Okay. Well, Disney says, okay, let's take a look at where this happened. They've got cameras everywhere, of course. So they're taking a look at it. Oh, here you are. Yeah, I see you right here in this frame. You're in Thunder Mountain Railroad and you're riding in Goofy car number 4. That's where you got hurt. Well, we don't own Goofy car number 4. Who do you think owns Goofy car number 4? Goofy car number 4 LLC owns Goofy car number 4. So Disney turns and says, here's some wrenches and a screwdriver. You can go ahead and take Goofy car number 4, but that's all you can get because it's the only asset in that LLC, Goofy car number 4. And it stops the lawsuit right there. Another big one, Walmart. Somebody trips and falls in the parking lot, gets hurt, parking lot of Walmart, let's just say. Well, bottom line is this. What are they going to do? They go get an attorney. They think they're going to get rich suing Walmart. Walmart says, that's not our asset. That asset is held by another LLC that has nothing to do with us. Oh, the only thing you can get is you can get the asphalt and the light poles. Those are the only assets in the LLC. Bottom line is this, you guys, you get the idea. Fact is, these big dogs do it. Why aren't you doing it? You should be doing it. You need to implement this because it works phenomenally well for the largest companies on the planet. And that's why you should be doing that as well. Okay. Bottom line to remember is this, that when there's nothing to get, there is no lawsuit. When they see what we're talking about, motivation, those assets, when they can't get to them, no lawsuit. Now, we've already talked about locking up your safe assets in an FLP that you own, locking up your high-risk assets in separate LLCs so that they're all protected. Well, you know, these trial attorneys are constantly going back to their buddies in DC and saying, hey, can you give us a law that'll do this to try to get around the asset protection structures? Well, there are a couple of them that they got passed through. One of them is allowing a judge to pierce the corporate veil in a closely held corporation, which means it's just an entity with 100 or less shareholders or owners or members. Piercing the corporate veil allows a judge to satisfy a judgment. If they go into your entity and there's not enough there to satisfy it, they'll go to all your personal stuff, make those associated assets, and they'll take them. They'll liquidate your assets completely by doing that if it so calls for it. Also in 45 of the 50 states, judges have been allowed to dissolve entities. Well, that's not good either. So because of these 2 things, Legally Mine suggests, and I will suggest as well, a strategy, which is strategy number 3, puzzle piece number 3. And this is to set up an Alaska holding company. Now, Alaska is one of the 5 states that won't allow a judge to dissolve the entities by law. So when you set this up, you're going to set up your Alaska holding company. You're going to attach your family limited partnerships and your LLCs with all your safe and high risk assets. You attach them to that. Now those entities become sub-entities of the Alaska holding company, thus cannot be dissolved and are fully protected. In fact, there are 3 real nice reasons why I like this strategy. The first reason is this: it's called an anonymity clause, okay, which means no one can find out by law who owns those entities in Alaska. That's a great strategy. Now, even if the judge wanted to dissolve something, he or she wouldn't be able to do that because they wouldn't be able to figure out which one of those is yours. But the other thing is, backing that up, is you've got the no dissolution, meaning you can't dissolve entities up there either, so it fully protects you. And then the other thing is, it's not likely to change, and here's why. Over 35% of Alaska's state revenue through the government comes from these types of entities and setups. So, and then the Alaska citizenry gets a stipend check every year based on how much came in. So obviously they're not going to want to dissolve that anytime soon or change that anytime soon. All right. So now we've got 3 of the 4 puzzle pieces together. You see how they fit so well together, but we've got one more to go, because those trial attorneys went out and they went to their friends in DC again. They said, we need another law to get around this. So they passed a new law, and the law is called the charging order. Now, the charging order is simply this. The charging order is wording that's already embedded in the documents that an attorney uses to set up entities. In fact, most American business entities that are set up today, the small ones especially, have no idea about that. Very few do, in fact. But all the charging order says is this. It just basically leaves the back door open for that judge to come in and be able to take control of your entities and force you to distribute your assets. It's called pro rata distribution. Okay. Well, when we saw that, that's not a good thing. And so Legally Mine came out, and Jay Minton actually came up with strategy number 4, which is non-pro rata distribution. In other words, this is language that is replacing that pro rata distribution language. In fact, here's what it is. The non-pro rata distribution language basically says that only the general partner or general manager of the entity can order a distribution of assets, basically shutting the door on the judge, not allowing the judge to be able to come in and take control. That's great for us as clients, right? That was a big win. But at the same time, we had to understand it a little bit. We have to understand it. What this means is you need to have someone come in that understands where that pro rata language is buried, take that out, replace it with non-pro rata distribution language, and then file the amendments for you. That way, any entities you have are protected. Okay. But what this language did, this non-pro rata distribution language, and what it did was it gave us a huge advantage also as clients. And here's why. Because, well, let's just go back and let me walk you through an example here. Let's say I want you to imagine that you're getting sued for $1 million. It's on your desk. You've been sued. You're getting sued. Now, let's say that I'm the judge in the case. I don't know the plaintiff. I don't know you. And so I'm objective. And I look at it and I rule in the plaintiff's favor for $1 million. That's not where your interaction with the judge stops. You're now interacting with me all over the place, because now I come to you and I say, okay, let's take a look at how your assets are set up. Let's take a look at how we're going to set this, how we're going to take care of this. So I say, hand over your corporate documents to me. You hand them over. I take a look at those. And as I go through those, I see that there's pro rata language throughout these documents, which means I, as the judge, have the ability to take control of your entity and force you to distribute your assets however I see fit. Okay. Now, that's something that is pretty scary when you think about it. Think about having that judge just take it and say, you know what, here's how it's going to go down. You're going to pay that $1 million over the next year. You're going to pay it in equal monthly installments, about 83 grand a month. How would that feel? That'd put a big pinch on you, wouldn't it? It would for me too. So that was that first example. Now, the second example where you actually take control, right? Where, same lawsuit, everything's the same. You lose the lawsuit. I rule in the other person's favor, but I come to you. I say, let me take a look at your corporate documents. And I start looking through them. But let's say this time you had engaged somebody. You'd been proactive, somebody who knew and understood how to put that non-pro rata language in. Let's just say that you had that in place. So I'm looking through there, seeing all this non-pro rata language. I can't do anything. I lose all control. I can do nothing. So you get to decide, are you going to distribute anything to the plaintiff? Yes or no? And I bet anything your answer is absolutely not. We're not going to do that. Well, understood. I get that. And that's great for you. It's not good for the plaintiff though, right? Because the plaintiff didn't get any money, but it gets worse for the plaintiff. And here's why. In the first example, you gave $1 million to the plaintiff, right? Plaintiff, first thing that comes off the top, taxes. Let's say the plaintiff's in a 40% tax bracket, $400,000 before he or she could touch it, had to go to the tax man. It's a lot of money. In the second example, where you didn't distribute, how much money did the plaintiff get? The plaintiff got zero, right? And if the plaintiff got zero, then guess who else gets zero? The IRS, the tax man. And they don't like to get zero, right? And so what they did was they came up with a new ruling. And it's IRS ruling 77-137 gives us a huge advantage with the non-pro rata language. Anybody that has that. The ruling simply says that anytime a plaintiff uses the charging order to get a monetary judgment amount, the plaintiff has to pay taxes on that judgment amount, even if there's no distribution of money from the defendant. Now think what that just did, okay? That person won the lawsuit. The plaintiff got no money from you, and now the plaintiff is going to get hung with a $400,000 tax bill on money he or she is never going to get. Now, I don't know about you, but I'd be pretty upset with my lawyer that got me in that situation and didn't understand what was going on there, and that this non-pro rata language was so important. In fact, you can see now why this would just completely take that right off the table, that motivation to sue. When these guys see that non-pro rata language, massively important that they stay away from it. It causes them to drop lawsuits right and left. And so it's very, very important. So now you can see how all four of these pieces fit so well together. All four must be in place. You don't want to guess about it. You've got to make sure that you understand how these fit together. And if they do, you get them fit together right, there's nothing better than that security. So now you've got all your assets protected with this, right? We've got your assets protected. Everything's good. What's next? Well, what's next is you need to do a little bit of estate planning, right? You've got to get yourself an estate. And this is strategy number 5, estate planning. And essentially what it involves is a living trust, getting a living trust in place, and then having it address, keeping it updated, having it address all of your assets that you've had in place this whole time. I mean, think about this. If you only have a will or you have nothing in place, then when you die, all of your estate goes into the probate courts, and you'll notice avoids probate courts is for the living trust, right? But you need to make sure you understand that if they go into the probate courts, you got judges and attorneys that are taking all kinds of money out of your estate just to settle your estate, and they may make decisions you wouldn't otherwise have made. And when you have a living trust in place, and usually they cost anywhere, I'll just give you an idea, of $5 to $15,000 for a living trust by a decent attorney. But these protect everything. What will happen is when you pass, you'll have picked a trusted family member to be or friend to be your trustee to the trust. That trustee will read through your trust, and then all of those assets will get dispersed exactly as you wanted, exactly in the form and the way that you wanted to, and it addresses all of your assets. So remember, the big one, not disputable, and the other one avoids probate court. A living trust avoids probate court. Think about things like the question at the bottom: how will your family be compensated if you're in a practice and you die for some reason? You have to think about those things. They're very important. Let's have those in place. All right. Living trust, very, very important. All right. Now, I told you, one of the things I told you is that we have to talk about taxes a little bit, the tax savings side. Look, here's the thing. When you set this new structure up that we've talked about, you're going to be getting into a place where you've got a ton of available new tax benefits, right? And of course, who's going to help us? The IRS certainly isn't. The IRS says that it's our responsibility as American citizens to make sure we don't overpay on our taxes. They're not going to help us not overpay, right? Well, so what do? We've got this new structure in place. And with this new structure, there's tons of new benefits. How do you know where they are? How does your accountant know, or your CPA know? They don't study this out in depth. They know how to prepare your taxes. They may give you a couple of ideas, but the bottom line is you need someone that's a specialist. And I'm going to call in the tax strategist, okay? A tax strategist, they're CPAs on steroids, essentially, is what I call them. Now, because of that, because these tax strategists are so good, what they've done is they've spent their entire careers focused on the US tax code and how they can best benefit their clients to help them minimize their taxes in a legal and ethical way. So it's all black and white. Challenge is tax strategists are very, very expensive. None of us want to budget that into our own budget. So what we need to do is also find someone who actually can have access to that tax strategist so that you can get your taxes reduced as much as possible going forward. Now, I'm not going to hit on all these just in the interest of time, but I do want to share with you one of them specifically, and that is this. That top one, Section 288G. Now, typically, when you get this kind of asset protection structure in place, I will just tell you from my experience, you're going to find somewhere between 10 and 15 new tax saving strategies that you can implement. You just need to know how to do it the right way. That top one, 288G, has to do with the meetings that you have to do with your entities that you now own because of your asset protection. Every year, you've got to do various types of meetings. The IRS says instead of you going down and renting from the Marriott or the Hilton or somebody to have meeting rooms and paying a couple grand a day to do that. We're going to let you do this. 14 days a year, you can have those meetings at your primary residence, and you can allow your entity to pay you for that rent instead of paying for the hotel. They're paying you the rent for your primary residence being used. And your entity is paying you that, and it's 100% tax free, 100% tax free to you. Now, 14 days a year, that's the cap. And the average, depending on square footage and whatnot, you're about $2,000 a day. So 14 days a year times $2,000 a day, what's that? That's 28 grand. Now, I know that's not a lot of money, but it's 28 grand tax free. In other words, you would have had to make 56,000 pre-tax in order to have that happen and make the 28 grand. So these types of strategies are what they'll plug in, what you can get plugged in. You just need to know that they're there, and you need to find the right tax strategist to do just that for you. But huge, huge tax savings. Now you look at it and say, okay, now how do we implement these things? We've talked about a lot here in the last 40 minutes or so. We've talked about asset protection, estate planning, how your taxes can save you, the structure saves you on tax money and all of that. So the next thing you need to do is you need to understand not only how it's done, what is it, how it's done, and how to implement, basically. And really, in my opinion, there are two different ways you can implement these strategies that you want to have in effect in your asset protection. The first way that you can do it is do it like I tried to do it. I went out and I spent, like I told you earlier, I spent over 25 grand pulling these various types of attorneys into play. I was talking to everybody. Look at this. For the entities and for my estate planning, and these are all these things, tax attorneys, all that. It's hard to get them all to talk to each other, number one, and number two, it's really hard for them to agree on anything. You can imagine it was like herding cats trying to get that done. But I spent over 26 grand. I gave it a good go, and there were still holes in it. I knew. Now that's one way to go about it, is trying to figure it out yourself. Think about how little extra time you have. Do you really want to spend that extra time trying to find these guys? No, the best thing, in my opinion, to do, the best approach, is to find someone that does it all under one roof, kind of a one-stop shop, if you will, because now you've seen throughout the presentation how all of these entities and all of these strategies, how they fit so tightly together. If you're missing one, it's going to be a big hole. But to have that tax savings and strategies in place, it's a big deal. Getting it done by experts who are in the field and do all of these things because of how they fit so well together, that is the most important thing that you can do. Find someone who will do that for you. And then here's the other thing I will encourage you to do: take action. Don't put it off. It's too easy to put it off and not be aggressive about it. And if you're putting it off and something happens, guess what? You can't do anything at that point, right? So you've got to make sure that you take advantage of these things, you research it, and you take advantage of these things right away, so that you have that asset protection in place, so that you're getting the benefits of the tax strategies and so on. Okay. This ends the CE portion of the lecture. I want you all to write down this link. This will get you to that quiz. And then if you've got questions about that, you can reach out to Legally Mine if you're having a hard time getting into that. But it's lm20.live/quiz. That is going to be the link you'll want to go through. Okay, you want to go to. All right. And that's where you're going to be able to get the credits that you're looking for. Now, what I'm going to do now is, since that is concluding the CME portion, I'm going to spend just about 5 minutes with you here. Remember, I told you that I'm representing Legally Mine. Okay. Legally Mine, it was someone, and I'm going to share with you the bullet points as to why I became a client of Legally Mine back in 2011. And it's really simple to see. But Legally Mine is an asset protection specialist. If you know anything about, well, first off, in medicine, no matter what, I mean, why do we have specialists that go from a general practitioner to a specialist? Because the specialist hopefully has spent their time and have their execution on that area of expertise. It's no different in law. You have defense attorneys and trial attorneys, and you've got bankruptcy attorneys and corporate attorneys and on, litigators, et cetera. These are all specialists. Asset protection as a specialty, the American Bar Association tells us that less than 0.5% of all attorneys out there actually list asset protection as a specialty in their practice. Now, everybody listen, I just want to encourage you. When you take this step, you want to have the best people working for you that you can. just because your sister-in-law or brother or something is an attorney, unless they're an asset protection specialist, you want to have someone doing it that really knows their stuff because it involves your estate, right? So I took a look at them because of that. They'd been serving medical professionals for over 40 years. They have a 12-year rock solid strategy. In fact, what I just shared with you, that structure and strategy, 12 years going with over 12,000, many more than that now, medical professionals, and they've had not one single lawsuit continue, not one. That means they weren't settled. It means they were stopped, that they were dropped. Very important once they see that structure. And like I mentioned before, you have dramatic tax savings that are available to you, whether you're a W-2 employee, a 1099 employee, or you actually own the practice. You will see dramatic tax savings in any of those categories that you're in, right? Now, let's just take a look really quickly at their approach then. What they do is they have all of these things under one roof: asset protection, estate planning, tax strategies, the savings, and much more. They have all of those things in place so you can go to one place, have a one-stop shop. It makes it very convenient. And their whole approach for doing all of these things for you is $13,400, which is, unbelievable in my mind, just because of what I spent doing this. Okay. But they are providing all of this under one roof. The other thing that I wanted to just mention to you is by going this direction, as I said earlier, we're all super busy. We don't want to have to spend a lot of time on this. Well, this is a very painless way to go. It's less than half of what I invested originally in trying to get something like this put together with multiple attorneys. Very, very difficult. So what that means is you've got all of these things, including protecting your license to practice from the NPDB. All of those things are incorporated, involved in this one place, one price, $13,400. Now, what they like to do, what Legally Mine likes to do, is when they have an audience where they're talking to an audience about these critical things, they actually provide a couple of incentives to give you the safe feeling of having jumped in and gotten involved right away and getting this going. They know how important that is. So 2 things they've done. Number one, what they've done is they've cut that initial price down by $5,000 to $8,400. Now think about what that means. $8,400. I mean, gosh, if you got sued or even named in a lawsuit, okay, you had to get a defense attorney. What's the defense attorney going to do? First thing you're going to have to pay them is a retainer, and that retainer is going to be somewhere in the neighborhood of $5,000 to $10,000, typically, if they're worth anything. So this is far better than that, and provides you with a great set of protective entities. The other thing that Legally Mine is doing too, for those of you on this webinar, and again, they'll put a 72-hour cap on this pricing and the guarantee, but you just need to get a hold of me and then we can work through that. The tax savings guarantee is basically them saying they want to put their money where their mouth is. Okay, here's what it says. It says that if next year on your taxes, if you don't save at least $8,400 in new tax savings that you otherwise would not have gotten, Legally Mine will cut you a check for the difference between what you did save and the $8,400. They will true it up. You see here at the bottom where it says you will not pay for this, because where is the savings coming from, or where is the money coming from? It's coming from the savings on your tax dollars, right? So that's huge. In fact, speaking to the tax savings, one of our clients, Dr. Max, says our accountant has been very pleased. In the end, we're saving more than twice the cost of the program in tax savings each year. Think about that. Saving twice the cost of the program every single year. I'm very happy with the outcome and have recommended Legally Mine to all other professionals in my association. The way that $8,400 breaks down is simply this. $6,000 of it is for an unlimited entity creation agreement. You pay that once, you never pay it again. It's for any and all entities that you need to have structured all the way through for the rest of your life, for both you and your spouse. Okay, they could be medical related, non-medical related, doesn't matter. Let's say you bought a new rental property. You call up Legally Mine and say, hey, I just bought this rental property. Legally Mine is going to get the information. They're going to create an LLC to put it in. They're going to attach that to the Alaska Holding Company. And guess what? They're going to even address it in your living trust. They take care of all those things for us, so we don't have to. As a client, I've loved that feature. And I know also that those entities are all written the right way as well, with that non-pro rata language in them. So that's 6,000 of it. The other 2,400 is for the first year of their flagship service, which is their Premium Plus services. This is something, all of these things we've already talked about, is taking care of them for you. Personalized asset protection strategy, that's a blueprint that's shown to an attorney that's threatening or has sued you. As soon as they see that, that's what's been stopping these lawsuits and getting them dropped. 100% success rate with that. Management of your asset protection, making sure minutes are done, annual renewals on the entities are taken care of. I leave a card on file so that they can just ding me the $50 a year for the Alaska Holding Company. They just pass those things through and they send me a receipt. Now I know all of those entities are taken care of. The reason this is important for you is because if you get caught in court and the judge says, I'm going to take a look at your minutes, and you say, you know what, I forgot to do my minutes, the judge is going to say, okay, you don't have minutes, then guess what? You don't have an entity. We're going to dissolve that entity. It's one of their little tricks to getting to your assets. So we don't want to have that happen. Personal tax reduction strategy, that's working with the tax strategist that Legally Mine has, and it's all included in this. Working with them at any time and all times so that they can provide every year that new tax plan that's going to save you thousands and thousands of dollars. In addition to that, the license protection as well, and HIPAA, OSHA, and Medicare compliance. You also have access at any time to the staff, the attorneys, the tax strategists, all of them. They're all kind of on retainer for you. Okay. And then of course, the big thing to really help you feel comfortable, the tax savings guarantee is a written tax savings guarantee will be provided to you that says, the 8,400, you're going to make at least that and more in your tax savings, or Legally Mine will true up the difference and make sure that that's covered. Okay. Very good. The last thing here is just, I wanted to mention Dr. Brian Hanipsiak. He's the editor-in-chief of the American Journal of Orthopedics. He actually is a client of ours as well. He says, I immediately signed up for the service and it has exceeded my expectations. While most practicing physicians understand the importance of asset protection, so few take the time to act on it until it's too late. Okay, now everybody, when is it too late? It's too late when you get sued, right? Or you get a notice of intent to sue. So you need to get everything in place so you won't ever have to worry about it again, and you can start enjoying those tax benefits as well. So what I would say to you just in conclusion here is this. Don't wait to be forced to find out what your number is. Remember, we talked about your number early on. What's your number? Well, the fact is this right here should be your number. This is better than any retainer for any attorney that would probably cost you more than this anyway. Everything is fully tax deductible. You've got the guarantee in there as well. So it's really a no-brainer to get this taken care of. So what I'm going to do is I'm going to just, for those of you that want to take advantage of this over the next 72 hours, I'm going to give you that's my personal cell phone number. Write that down, shoot me a text. And over the next 3 days, anybody that has reached out and talked to me will be able to answer your questions. If you just have questions, if you're interested in getting this put in place, we can get you started there as well. I think I mentioned to you, it takes about 60 days for them to get those things done and get all of your assets moved. So I always tell people, just keep your head down, new clients, keep your head down. Don't make any mistakes for the next 60 days. But yeah, so it'll take about that long. So it's good to get going now because you'll be fully protected at that 60-day mark once things are moved. That's everything I had for the night.
We do have one question, and that is if you help clients in Canada.
In Canada, that's a great question. We don't, however, that's just because we haven't set things up in Canada. So yeah, this would be US based entities, structure, and so on.
Well, wonderful. Thank you so much for giving the presentation. For everyone watching, we will have the recording out to you in 7 to 10 days, along with all of the information. And we look forward to seeing you next month on May 12th. And thank you again, Stephen. We appreciate it.
Thank you. I appreciate that.
Have a wonderful evening.